And we have a lot to talk about, folks, with the Brendan Dassey case, a case that has lived with me since I was a local journalist in Wisconsin, and I was in a newsroom when that victim, 25-year-old Teresa Halbach, was reported missing. From there, everything rolled out, and eventually the Netflix film Making a Murderer was indeed made to examine the case. We're going to talk a lot about that case for the next couple of minutes. Michel Bryant is a former Court TV correspondent and attorney. He's here in New York City with me. And LaDawn Jones is on the line from the Atlanta, Georgia area. She's an attorney there. We're going to break down a little bit about the Dassey case. Good to see you both this morning.
Morning, Aaron.
So let's talk about this. So the U.S. Supreme Court has been asked to hear whether or not Brendan Dassey's confession was voluntary and therefore admissible, or whether it was coerced and therefore inadmissible. And that's a tough line to draw. This has been back and forth, working its way through the various state courts and the lower federal courts, with decisions going both ways. So, Michel, what do you think? I mean, should the Supreme Court just defer to the lower court here? The last lower court said this was proper evidence, but then the two federal courts underneath that court turned around and said, no, this should have been thrown out.
Remember, this is a huge issue as to whether or not the Supreme Court will even look at this case. If you take the 600 or 700 requests for certiorari they get every year, they take 10, 11. It's 1 to 2% of the total. So that's a huge hurdle. Why do they limit their work so severely? Well, it has to be a case that involves something more than some factual dispute, something big. It has to be a big issue. So the question here is whether or not this issue of juvenile confessions has been properly evaluated recently enough to avoid any confusion in the lower courts.
That's exactly the argument that Brendan Dassey's defense team made in briefs filed in front of the court. I think they made the argument very skillfully. It was a great argument. The question is, will the justices agree with it? Now, LaDawn, they have to get 4 justices in the conference meeting, which happened yesterday, to agree whether to pick up a case, but that's not enough for a majority to actually make clear law. So by accepting the case, that doesn't necessarily mean that the court is going to agree with or disagree with the lower court. It results in yet more questions in this case.
Absolutely. And so let's assume that we get over the hurdle and it actually makes it before the justices to consider. We still have a fundamental flaw built into our justice system. Whether or not these justices can decide if it was coercion or not, it also relies not just on the facts of the case, but on their personal experiences. And I've sat in the room as a prosecutor while police interrogate someone, ask them questions who are suspects of a crime. And this takes a lot of hours. It's a lot of energy. The people are hungry. The age makes a difference. The circumstances. Was it cold in the room? All of these different factors the courts have to look at with the totality point of view to determine whether or not this was a coerced statement. And the problem is that the justices that are going to be making this decision are likely people who have not been on that side of the table in one of those rooms to really determine what factors make you say something that you may not really have done. I mean, that's a big hurdle for someone to confess to a crime that they did not do, or make a statement that leads to their guilt about a crime that they may or may not have committed. And I think no matter what, inherent in our system, the justices looking backwards at what may have happened some years ago in a room is just going to be a hard decision on either side.
Yeah, I agree. And I think that summarizes it very well, because there are a couple of different ways to view that confession recording. One is to look at it and say, well, it's a young man, not even, fully, graduated from secondary school or anything like that, who's being led into a room by 2 older guys who are experienced interrogators, and they're sort of feeding him details about the crime scene and telling him that if he tells the truth and basically agrees with him, then the truth will set him free, and that they'll go to bat for him. And so the accusation here from the defense team is that, look, he just went along with everything that they told him to say, and then thought he was going to be allowed to go back to school. That's what the defense is saying here. The state is going into this kicking and screaming and saying, no, that's not what happened. What happened was he fudged some of the details, but ultimately he told the truth most of the time, or at least enough of a time to present it in front of a jury. One of the big issues here, though, Michel, is, look, the federal habeas corpus statute, which is where this procedure sits legally, requires the federal courts to give a lot of deference to the state courts. And the most recent decision, the en banc panel, the full panel in the Seventh Circuit, basically said, well, you know, look, there was a hint in there right off the top that said, we don't really like this confession, but the state court's decision was not unreasonable in allowing it. And that's a key distinction.
It really is, and that's a very
razor-thin line.
And it's a little loose there, reasonable. I mean, what exactly does that mean? And there is great deference given to the lower courts. And otherwise, the Supreme Court would be overrun with cases that even they felt needed to be addressed. You have to defer to the lower courts. They were there. They had better analysis. And unless it's an issue that goes against some series of cases, which is key too. What are the precedents? Does the Supreme Court need to step in and fix something? That's really what they want to find out. Do we need to fix something and use this case to do it?
Yeah, we're going to continue to monitor this situation. The U.S. Supreme Court expected to announce on Monday morning whether or not it's going to take this case that millions of people watched. We're going to keep a very close eye on it. Keep an eye on lawandcrime.com for updates as soon as that decision comes down. But we're going to go to the Georgia cold case that we've been following here on Law and Crime. This is the Frankie Gebhardt trial involving allegations that there was a racially motivated murder of a man named Timothy Coggins. We're in session in that courtroom now live, so let's listen in. And ladies and gentlemen, there's a sidebar going on as soon as we pitch to court there. So look, just horrific accusations here. You've got this African-American man, Timothy Coggins, the allegation that he was stabbed, he was dragged behind a truck, and basically left for dead in a grassy area near some power lines some 34 years ago. Michael, the accusation here is haunting. We've heard a lot of racist language in this courtroom. The prosecution's opening statement was blunt. And yet we also have a defense saying, look, the state botched the case by closing it too early and losing a lot of the evidence. And the bottom line is prosecutors are saying the original police who investigated it screwed up. Maybe they didn't really want to get at the truth. And it's rare for a prosecutor to get up in court and say something like that.
But pretty smart, if you think about it. You know, that way you're diffusing the issue that the defense is certainly going to throw out there to the jury. You've already owned up to it. Okay, so let's set that aside, jury members. And now let's focus on what we do have. And what they do have are a lot of snitch statements, for lack of a better description. Mm-hmm. These are witnesses, some of which are doing time, who might want to deal by helping out in this case. So the prosecution has an interesting hurdle here.
Yeah, it's a hard hurdle to take. LaDawn Jones, you're in Georgia. This case is being tried in Georgia. Really hard case for prosecutors, but look, the defense has a point. It's still ultimately the state's burden to prove this case beyond a reasonable doubt. And you've got the only clear link here is from witnesses who have pretty colorable pasts themselves. Absolutely,
but it's not that uncommon to have a case that is based entirely on witness testimony. It is uncommon to have a case based entirely on witness testimony that is 30 years old. And so you're dealing with memories that have changed, things that could become blurry, hard to recall facts and times and colors and where you were at the time that these events occurred. Just to put a little description about it, I've tried a case before, Judge Fletcher before, Fletcher Sams. He is a very fair jurist. He's going to look at both sides and listen, no matter how crazy the facts may be, and make sure that he comes down fair on both sides. It's been my experience with him. But this particular area in Georgia in the 80s is when, after white flight occurred out of the city of Atlanta, out of the metro areas, and it was just far enough south of Atlanta to where it was true in the 80s that African Americans were still considered lesser than. And so what that means for the prosecution is that I'm surprised that this case has as much evidence available that it does.
It looks, yeah, LaDawn, I understand. I certainly appreciate hearing the local perspective on things, and I want to talk a lot more about that with you. But it looks like we've got live testimony back in court, so let's cut back in. Again, this is the case of Frankie Gebhardt. He's accused of killing Timothy Coggins. Welcome back, everybody. We're going to take a quick pause from the recording of this particular defendant in the midst of a police interview. Some of this is hard to hear, but there's sort of a basic trajectory here. They bring him in, they ask him about a friend who's in a cell, and then they eventually move into questions about the Coggins murder, and you could just hear all sorts of racial language being spewed about by this defendant. He's fighting with the interrogator. They're trying to bait him by saying that they've got his DNA, and he says, I don't know anything about this crime. I never bragged about it, never said anything about it. He was asked a lot of different questions here. LaDawn Jones, attorney in the Atlanta, Georgia area. LaDawn, this is happening about midway between where you sit and Macon, and you started to tell us earlier about some of the local history, and what do you make of the history when you couple it with what we're hearing in court right now?
You know, I find it really interesting that the witness is very opinionated, strong and opinionated in his discussion with law enforcement, right? It's almost as an entitlement. Here you are being interrogated about a very serious potential crime. He knew before he went into that room the general nature of what the issues were, right? As you mentioned, they baited him into it. And he just seems to have a little empathy for the seriousness of what's going on, right? And the seriousness of what he's being asked is quite cocky in the way that he's presenting. I say all that because when you talk about this area, the reason why in 1983 someone may have thought it was appropriate to drag a black man because he was courting a white woman is indicative in the way that this witness is speaking to law enforcement while investigating this issue. It is almost as if they had a right. It was okay, it was allowed, that this type of language that was used was appropriate both during that time and then later on during the investigation. So I find all of that to be extremely interesting. The other thing that, you know, us attorneys always find, it is amazing when someone seems to remember absolutely nothing. They say, I know nothing again and again, and then suddenly something jogs their memory and they're able to remember details, and it's always those details that get them out of trouble or keep them out of harm's way. So his testimony was, or the recorded statement was quite interesting.
Yeah, I mean, this is still playing out in court, and boy, I wish I had the full transcript of this. I think you hit the nail on the head, though, LaDawn. Look, it seems to me, and perhaps I'm naive here, but this almost feels like a case that would have been going on before the civil rights movement even happened. And yet we're here listening to it. I realize it's a cold case that happened in the early 1980s, but we're listening to this in a courtroom in the year 2018. And the language, the accusations, the tone, the demeanor, we can't pick up all of the defendant's words because the recording isn't of the best quality, but the body language is speaking volumes, or the vocal tone is speaking volumes. Michael, what do you think?
You know, it's funny how you listen to him answer questions, and even if you can't hear exactly what he's saying, his register goes up the more irritated he is, and it makes him sound very defensive. You know, were you there? I wasn't even there. You know, he gets way up there, and it's a very defensive position vocally.
Yeah, I mean, LaDawn, I know that you need to head out to do some other work here in a couple minutes, but I wanted to ask a couple of final thoughts about this as we march through the testimony here. You know, oftentimes there is stronger evidence against defendants. Here, we've got a couple of things. We've got the defendant's own words, which implicate him in at least a minor way, based on the way he's responding to these questions, which are denials of other conversations that a slew of other witnesses say that he had. So a bunch of witnesses say he said something implicating himself. He is throwing a fit, saying, oh, I never said that. But then you've got some statements from these witnesses that the defendant bragged about throwing weapons that were used in this crime in a well, and then all these years later they dug the well up and found some of the things that those witnesses said would be in the well. Those are the key links here, linking this particular defendant to the accusation that he killed Timothy Coggins. LaDawn, I'll put you in the jury's role here. Is it enough?
You know, when we always look for a smoking gun in a trial, I will say that the knife in this particular case, if the medical examiner and the state is able to connect the size and the shape of the knife with the injuries that were found on the victim's body at the time of death, if they're able to make a connection there at all, right, where it's not ruled out, if the defense is unable to undermine that knife, I think that is the smoking gun in this case. I mean, after this recording, the jury's not going to like him, right? There are his statements to several different people at different times. So these aren't people that came together and colluded in order to stand up against him. And then that knife, I think, may be enough for this particular jury. And then let me go back to the local thing. In this area, although at the time was predominantly white, has dramatically changed over the last 30 years. And so the jurors that are before them now are very different than the jurors that would have been there in the 80s. And I think that might be the key portion to a guilty finding in this case.
I really appreciate the local history, LaDawn. I mean, you live not horribly far away, but how far away is this? Is it an hour? Is it less than that? A little bit more from where you sit?
20 minutes max.
Oh, wow. So it is almost in your backyard. I mean, that's a quick trip out of Atlanta. So LaDawn Jones, attorney from Atlanta, Georgia, we really appreciate you joining us on this one. I know you have to run, so we'll catch you later on in the next case.
Thanks for having me.
Okay, we're going to dip back into court as this recording with the defendant being interrogated by an investigator continues to be played.